ಯುವರ್ ಆನರ್, ನಾನು ಅಕ್ಯೂಸ್ ನಂಬರ್ 2 ಶಿವಕೃಷ್ಣ ದೇಸಾಯಿ ಅವರ ಪರವಾಗಿ
ತಾವು ಹೇಳಿದ್ದು ಸರಿ ಯುವರ್ ಆನರ್. ನಾನು ಅದನ್ನು ಗಮನಿಸಿರಲಿಲ್ಲ.
May I make a small mention at this stage, my lords? The entire, my lords, this is the fourth application for the grant of bail, my lord. The offences are under sections 379, 120B. At the very outset, I will submit, my lords, that all the contents, otherwise which do not lead to a discovery, are inadmissible under section 27 of the Indian Evidence Act. Now, my lords, within this confessional or disclosure statement, as what is colloquially referred to, that is 99.9% of their case rests upon these long and lengthy explanations which keep coming in the memorandum statement, all of which lead to no, I cannot be called upon to answer about Millard's anything and everything against me. The circumstance which the prosecution alleges against me must be prima facie incriminating for me to be called upon to answer. That is which we call the initial burden of proof which the prosecution needs to execute. Till they don't execute that burden, I cannot be made answerable for anything and everything. For suspicion to take the place of prima facie proof, there is still a big gap, my lords. Now, Millard's coming, these are the facts of the case. So in a nutshell, what I'm submitting before my lords is there is no legal evidence to connect me with this matter, my lords. They have only recorded everything is in the form of a memorandum statement. All the explanations and memorandum statements which are inadmissible in law. Now, my lords, the legal question which I am very sure will impress much more upon my lords than my factual argument. There was a recent judgment, my lords, which got passed by the Supreme Court, rather celebrated judgment on the question of bail. That was, my lords, the case of Satinder Kumar Antil versus the Central Bureau of Investigation. I have it reported as, my lords, 2022 SCC online, SC page 825. Those are all my submissions which I'm putting before my lord. Apart from that, also, if they find that I am not complying with whatever notices they are issuing to me, whether under 160, whether under 91, whether under 41A, that they require my presence after bail is granted, they are always at liberty to get my bail cancelled by my lords.
Yes.
Now, my lords, in these circumstances, my lords, I pray that my lords may grace indulgence towards my side and allow my application.
Sorry, I'm not getting it. How does sovereignty come into it in power of excommunication? The Constitution doesn't permit us to excommunicate anybody. So there is no. So therefore, see, ultimately the same thing. It's not. Let's not expand it to what you are saying. The simple issue is whether there can be an exercise of power of excommunication, and Mr. Bhatnagar said that's all, and he seeks to test it on a constitutional provision. Now he says that frame this question and refer to a 9 judges bench. Mr. Nariman says no. Let us see the answers to the 9 judges bench and then take up this matter. That's the between the two on the submission.